It's a great day here at Elville and Associates, and welcome to our Elville webinar series. A very happy new year to you and yours. I think I can say that for another week or so. I'm pleased to share with you our topic today, the first of many special needs planning discussions we'll be offering throughout 2024. What families need to know about planning for a loved one with special needs. Presented by Elville and Associates Managing Principal and Lead Attorney Stephen Elville. My name, as always, is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be your moderator for today. You're at the right place for high-level legal education, and we encourage your general questions today. So please note them in the chat panel or question section on your screen, and we will pause periodically to address them. And your questions always add value and help others learn, so don't be shy in posing your questions at any time. You also received the presentation slides by email yesterday that Steve will be referencing to take notes on them if you wish. These materials are also available in the section marked handouts on your panel screen to download at this time. For our professionals on today's webinar, a warm welcome to you as always as well. 1.5 continuing education hours are available for most everyone in attendance. If you'd like to submit an ID number and your accreditation for me to provide a certificate of attendance or submit your information to the CFP Board of Standards, please send that information to me if I don't have it already. Everyone will also receive a post-webinar feedback email right after the presentation, so please take just a couple of minutes to fill out this very brief survey and offer us your feedback about today's presentation. And we read and value every comment that you have to share with us. And as I've mentioned, we have several new presentations coming up in February that are a direct result of the thoughts and comments that you've had to share with us. We appreciate that very much. And as always here at Elville & Associates, we always want to be a resource for your family and you in any way. Any planning needs that need to be addressed, old documents that need to be reviewed, or perhaps any other matter, Steve and our team are here to help. So I'd like to offer Steve and the firm a brief yet proper introduction before we get started. We have a poll that I'd like to share with you to learn who's with us today and what's brought you here, and then we will jump right in. So you should be able to see my screen here. Elville & Associates, founded in 2010 by Managing Principal and Lead Attorney Stephen Elville. We have several different practice areas that we offer here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, tax planning and asset protection. We have 9 attorneys, 12 staff members, and 5 locations. Steve and I are coming to you live from the snowy Columbia Gateway community location today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. We focus on education a lot here at Elville & Associates. We do that in several ways. First, through our planning processes with our clients. Next, through educational webinars and workshops in the communities that we serve each year. And also by way of our accredited client care program. We are one of only 2 firms in Maryland to have a client care program accredited by the Client Care Academy in Boston. We have our first quarterly continuing legal education event for our client care program members this Saturday at Anne Arundel Community College, and we're looking forward to that. We also focus on the ideals of client education, collaboration, and compassion in mind with every client every day here at Elville & Associates. Just a bit about Steve. His work as an attorney for the past 23 years has been centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection. A member of many different national membership and professional organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. Steve works to bring peace of mind to clients by offering solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. Steve is a very seasoned speaker. If you haven't heard him offer presentations before, offering many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Steve was also named to the Maryland Super Lawyers list for a 9th time and 8th consecutive year in 2024. So congratulations to Steve. He also had a feature story written about him in a national Super Lawyers magazine about the Elville Center for the Creative Arts. which is our firm's charitable organization he founded in 2014, and I'm very fortunate to be the executive director of. If you'd like to learn how we work to make a musical difference in the lives of children each day, please feel free to reach out to me when we have just a bit more time. I would love to share our story with you. But today, we're going to focus on special needs planning. And I have a poll to share with you. I'd love to learn what has brought you here today. There's a lot of things to do on a snowy day. People might be getting back to work, but you're here today with us, and we appreciate that. And our poll is, to get to know our audience, please tell us what has brought you to today's webinar. And your options are, first, I need to set up planning for a loved one with special needs. Second, I have planning in place, but it needs to be revisited, which is not unusual. Third, I'm a financial advisor here to learn to benefit my clients. And last but not least, I'm an interested family member here to gather information. So whatever's brought you here, thanks for being here. You're in good hands. And we'll take 10 more seconds. Okay. Steve, 40% say I need to set up planning for a loved one with special needs. 20% say I have planning in place, but it needs to be revisited. 9% say I'm a financial advisor here to learn to better serve my clients. And it changed just a bit. So 36% say I'm an interested family member here to gather information. So thanks to all that let us know why they're here today. Steve, I'm going to make you the presenter.
Thank you, sir. Very good, and I thank you, Jeff, for that wonderful introduction.
My pleasure.
It looks like we're going to get my slideshow started here. And I just want to reiterate what Jeff just said in that wonderful introduction. Thank you for being here. For whatever reason you may be attending today, I know when I got into Columbia this morning, I always notice when I drive over from my particular location that it's always cooler in Columbia. Well, it was 12 degrees here when I got over here this morning, and wherever you are, if you're in Maryland or anywhere near Maryland, I know it's very cold in many parts of the United States and Maryland right now. So thank you for being here. And I just want to thank Jeff for also his commitment, not only to our webinar series and being our wonderful moderator, but also for his commitment to special needs and the special needs community. So thank you for that, Jeff, all these years. And I also want to welcome not only our regular guests here today, but our special guests from Pathfinders for Autism and also people that may be attending by way of communication from the Brain Injury Association of Maryland. So welcome to our guests and special guests. And we're gonna educate this morning. We're going to be very efficient. There's a lot of information to share. Your time is valuable. And I also happen to know, having worked with families with a loved one with disability all these years, that you know, it's difficult for you. It's difficult for you to take the time and to think about yourself and the planning for yourself. For example, this Saturday, as Jeff mentioned, we're having a client care program at Anne Arundel Community College. One of the issues we're going to be discussing is powers of attorney, financial powers of attorney, which is beyond today's discussion. But one of the reasons that's very important is not only to take care of yourself and think about yourself, but also the power of attorney is one of the biggest issues in special needs planning, because your financial power of attorney to protect yourself and your spouse, if you're married, is also something that actually protects your loved one with disabilities and your neurotypical healthy children, if you have those kinds of children also. So these things all tie together. They're all one big piece of information that is important to understand. But today we're going to focus on the special needs planning aspect. And that in and of itself is an entire field of endeavor. But if you walk away from today's presentation and you feel like you've gotten one or two substantive things from this presentation, then we have accomplished our goal. We want to be a resource to you and give you something substantive to understand and think about, and also to plan for and be able to take the next steps. Education in itself is wonderful, and we focus on education here at Elville and Associates. We're very proud of that, but also taking the next step and having the ability to take that next step and to understand how to do that is also what we're here for today. One of the things I wanted to bring up at the outset of this presentation is I was talking to a client recently and I heard something very unusual. I heard that this particular client was in a listserv or chat room and was actually part of a discussion where the idea was being put out there that it was very difficult to do special needs planning, or that it was impossible, excuse me, to accomplish the proper planning for a loved one, or that it was risky and this kind of thing. And I had just never heard this before. And I just want to bring this out at the outset of the presentation, that if you've heard such things, I want to assure you that this is not the case at all. That was misinformation. I don't know where it came from, but this person was very upset and said that several other people on the chat room were also kind of affected by this information that seemed to be so counterintuitive. So I just want you to know that kind of information is completely incorrect. There is a lot of misinformation out there, but you should be assured it is absolutely possible to do the proper special needs planning or / estate planning for your loved one with disabilities. It's absolutely possible to work through the issues, absolutely possible and very straightforward with the proper counseling and the proper setting and the proper process to go through a process where this proper planning and proper financial planning and other planning for a loved one with disabilities can be accomplished. So I just wanted to make that clear at the outset. This is a formal webinar, but in many ways an informal webinar. And one of those issues is that Jeff is a great moderator. He will take your questions. He will know when to stop me if you have a particular question. So feel free to make notes, feel free to ask questions, feel free to have a free-flowing conversation. Please get a tablet out, please get your paper and pencil out, please get your computer out, make notes if you need to about what you're hearing today, but know that Jeff has provided and will provide a hard copy of the presentation for you. So welcome again, and here we're going to get started now. This is not legal advice in the traditional sense. We don't have an attorney-client relationship yet because we have not met yet in person. If you wish to meet, we will meet, or we can have a Zoom call, or we can have a telephone conference. But this is high-level information for education only and cannot be construed as legal advice, as you can imagine. So many of you, all of you, have unique situations. Some of them may be similar, but many of them or all of them are unique in and of themselves. When we plan for a loved one with disabilities, it's really about enhancing that person's quality of life, understanding the lay of the land with your loved one's life and what can and should be accomplished for them to the maximum extent possible to protect them as much as possible and not restrict their abilities or potential. I know this is a very general definition of why one should plan. There are many reasons why you in particular may be motivated to do planning for your loved one. Only you know their particular situation and yours. Only you know what really needs to be accomplished. The legal framework for that is what we can help you with, and we also will help you through the thinking process and the time to consider, and also having a planning team as part of the process. We can help you on all of those educational pieces, all of those legal pieces, but it's going to be driven by goals and what your goals are and your why of why you want to plan. Some of those things are going to include providing security financially. Huge issue. Whether that should involve life insurance, whether it involves other assets that you have that will fund financially a special needs trust or the lifestyle of your loved one. Public benefits, understanding those. Having a proper team, we talked about that just briefly a moment ago. Financial advisors, CPAs, life insurance professionals, advocates. Having this particular proper team in place is something we're here to help you with or to help augment what you may already have. Planning for appropriate housing and advocacy. We know this is a big deal. This is a big issue for many of you. And some of you are planning to solve this problem about housing and advocacy because you're taking proactive steps now. Some of you are going to rely on, which many people do, the idea of public benefits and group housing and so forth. But the issue of advocacy and housing, these are some of the big issues, and advocacy in particular seems to be one of the biggest issues facing special needs families right now. In the future, who will be there to advocate, not to be the trustee, even though that's a big issue in and of itself, but who's going to be the advocate, planning for and providing care, coordinating care with the family and extended family, keeping the beneficiary safe from predators and creditors and basically from fraud and abuse, preserving assets for other heirs, which is sometimes an ancillary goal in special needs planning. So not only planning for the preservation of assets for our loved one, but also to provide that, God forbid, at their passing, funds will pass free of a state lien or free of a state claim, if possible, to other beneficiaries. So we talked about an advisory team. And one of the things that Jeff and I do in our webinars many times is we are redundant. And sometimes we are very redundant for specific reasons. We want to drive home certain information. So we want to have a right team of advisors for you. One of the things I've noticed over the years is that families with loved ones with disabilities many times struggle with time to think, time to plan, but also having this team of advisors. Now, this is not always the case. Sometimes there are families that have this team of advisors. But if you don't have this, we want to help you form this team. We want to help you find these resources so that we, as lawyers potentially for you and special needs planners for you, can also work with your collaborative team. Only in this way can the planning really work well, really work the way you want, and you to have peace of mind. We want to build flexibility. So we've talked about the team. We want to have flexibility. Are we living in a changing world? The answer is a capital Y-E-S. Yes, we're living in a very changing, fast-paced world. Almost on a daily basis, it's changing, it seems like. We want to have the flexibility in the planning to change with the changes. So be able to go with the flow and not have a plan that is antiquated someday because it's static and it doesn't allow itself to adjust over time. So we want to build in that flexibility. Advocacy, we talked about that. One of the ways, by the way, this bottom bullet point, one of the ways to deal with flexibility is to utilize special fiduciaries. Now, I know I may have just lost some of you, trying to be humorous here, by using a fancy word, special fiduciaries. A trust protector is a special fiduciary we're going to talk about today. And by using these modern tools, such as a trust protector, a very special advisor, a very special fiduciary that can be part of the planning to give this flexibility. This is something that you need to educate yourself on and take advantage of in most cases. So let's talk about creating an effective plan. And again, some of this is going to be redundant intentionally. We're giving you a lot of information today. We're going to circle back, just like we're practicing for, let's say Little League Baseball. We're practicing the fundamentals over and over so that you, as very busy family members or parents of a loved one with disabilities, can retain some of this information and know that you can use it fundamentally. So I've mentioned some of this already. We want to envision the future, give you time to think, which we know is a challenge for many people today, no matter what their situation may be. Thinking about how our loved one will live in the future, what type of care is required, where will they live, who are the ancillary players that are going to support them, support the trustee, support the trust protector and the advocates. What kind of lifestyle do we envision for them? What are the future challenges that we could face, and how can we build layers? Think about this. You are the first line of defense for your loved one with disabilities. And then we have the world of public benefits that has been there and hopefully will always be there. We have no reason to believe that layer is not going to exist. But when you build a special needs plan for your loved one, you're creating another world, another layer on top of you being the first line of defense, public benefits, and then this other layer that you're creating when you are incapacitated or no longer living. So we're wanting to think in terms of building layers, and we want to work through a process I see many different documents. I see people coming in to review their special needs planning, or what they thought was special needs planning, but it was incorrect, or the documents are now out of date, they're antiquated, or they don't comply with the law. So understanding that planning is a process, allowing yourself to relax, even though this is a lot of information, and understanding that your purpose, if you have that purpose, that will drive the process. And as long as you're willing to be a good student, you can learn and you can take advantage of the planning opportunities that are there for you today. One of the big steps that you can take, in my opinion, is creating a memorandum of intent. So let me explain what this is. Arguably, this could be one of the most important tools that you ever use in your special needs planning. Of course, your special needs planning has to be fundamentally sound, okay? But what we want to do is think in terms of, what are the informal instructions that I can give to my trustee? I'm going to do a lot of thinking. I'm going to put this plan in place, but what's going to happen when I'm no longer here? And will my trustees understand what my loved one is really like? The people who are not necessarily your loved ones that already know your loved one with disabilities, but what if an unexpected person, a person that's on the outside, now becomes the trustee of the trust? Will they understand all that there is to know about your loved one, their family members? Who are their doctors? What are their eccentricities and preferences and needs? And sometimes this memorandum of intent can be a simple paragraph in the trust itself. Many times it takes the form of an actual memorandum, and we're happy to send you a template so that you can kind of see what we're talking about. And that gets attached to the back of the special needs trust. And this can be something that really gives personality or uniqueness to your estate plan and your special needs plan. Or it could be an entire manual that is created for the care of this loved one, and how that manual can be updated over the years and made contemporaneous with the ongoing planning. This is something I want you to take seriously. And here's why. There are millions of trusts out there. Imagine that there's just millions of all kinds of trusts. Very few of them have a memorandum of intent or a letter of wishes, we might say. So the memorandum of intent is going to be more factual about what your loved one is like and what they need and where their resources are, because we want to think in terms of, what if a stranger, what if a independent or new trustee of some kind were to take over the special needs plan someday, the special needs trust, I should say, and what if that person really had no idea about your loved one? This memorandum of intent would give them the information they need at a glance at their review. So I want you to think about this. I want you to keep it updated over the years, and I want you to make this part of your special needs plan. Now, on the financial side, we talked about using financial advisor resources. If you don't have a financial advisor, it's not absolutely necessary, but we strongly recommend it, that you use the tools that they bring to bear to help you budget and help you consider, how will you actually fund this? Many of you have retirement plans, many of you don't. Many of you have non-retirement assets more than retirement type assets. But the question of, at our deaths, how will the trust be funded? This is a huge question, because the truth is, none of us really know how much we're going to have when we actually die. So one of the things to think about is, should we use life insurance? Should we use other resources? What is our situation with regard to how we are situated to leave assets to our loved ones, including our loved one with special needs? These are old-fashioned spreadsheets that you could easily use in new apps that are on our devices and are available on the web. But what we want to illustrate here is, use your advisor's resources, use the resources that are out there for you to project, to think through the financial issues. Many of you do have financial advisors, and you're using projections, you're using their tools. Some financial advisors are going to have resources through their broker dealers about special needs tools, just special needs planning tools, I should say. And we want to look at any existing life insurance you have and evaluate it. One of the issues is what are we going to do personally with regard to our loved ones' incapacity? So we understand that many of you have loved ones with disabilities that are at various levels of functionality and capacity. Obviously, in a best case scenario, or in a perfect world, our special needs loved one is going to have the mental capacity to sign powers of attorney and advance medical directives. This avoids guardianship. Others of you already have guardianship for your loved one, or they are in the process of needing a guardianship when they turn 18 years of age or older, and you're going to go down that path, or you're going to be looking at what is supported decision making. And we have an entire webinar on this subject for those of you who are not aware of what supported decision making is. But supported decision making in some ways is an alternative to guardianship, and at the same time, it can stand on its own and can be part of the loved one's capacity to be able to direct their own lives. It can also be a part of guardianship for someone who is under guardianship, although right now we are seeing this new law, supported decision making, really playing out. It's been around now for over a year. We're seeing it play out in courtrooms about what the judges are allowing and not allowing as far as a person who's actually under guardianship being able to appoint a supporting decision maker, which the law allows for. But we are seeing quite a conservative approach from the judges, and it's something that we're going to be concerned about going forward. But the issue here is my loved one of the mental capacity to be able to sign his or her own powers of attorney and advance directive to avoid guardianship? Do we need a guardianship? And so we're going to pursue that avenue, or does my loved one simply need a supported decision-making agreement, which we have, even though it can be verbal or otherwise? And how does that supported decision-making idea play out between capacity and incapacity under guardianship? This is something that we need to be careful about. We need to be mindful about as you think about special needs planning. Jeff, I'm going to stop just for a second, take a sip of water. Is there any questions so far, Jeff, or should I keep going?
Thanks, Steve. No questions as of yet.
All right.
Please continue.
Probably our audience is putting more wood on the fire to stay warm. Okay, let's talk now about public benefits, and it's critical for trustees to understand public benefits. We're going to get our minds around these three core concepts. And many of you on this webinar understand this intuitively or actually already, but I want you to think in terms of these three divisions, I guess. SSI, supplemental security income, SSDI in the middle, and Section 8 or HUD benefits on the right-hand side. Many of you are aware that SSI is means tested. The SSI benefit in 2024 is going to be up from 914 last year. I don't recall the exact number, but I think we have it in the slide coming up. And SSI, by definition, is means tested. Your loved one cannot have more than $2,000, which has been around for a long time, that means tested limit in their name. And as a result, the loved one gets medical assistance or Medicaid in Maryland. So we know that we have to be concerned about this. And one of the reasons for the development of a special needs trust, or supplemental needs trust as we'll call it, is to preserve those means tested benefits. Now, if a person was disabled prior to age 22, that person will be considered an adult disabled child, or if we want to say it differently, a disabled adult child. And that person is going to get Social Security benefits under their parents' work record and not their own. Although some people, when they become adults, will have their own work record, even though they are disabled. So that means, and many of you do not know this, so please pay attention to this. When you retire or die, with a retirement meaning you start your Social Security benefits for yourself. If your child was disabled prior to age 22, they will move from the left-hand category into the middle category as a disabled adult child, and they will receive 50% of the amount of your benefit. They will also receive 75% of the amount of your benefit when you pass away. And they will actually get Social Security disability, Medicare, and medical assistance. Many of you are already in that situation with your loved one with disabilities. You understand what I'm saying. Some of you are families where your loved one with disability has not transitioned yet to SSDI, or they were not disabled prior to age 22. So this is very confusing. The right-hand category is really something we're not going to spend a lot of time talking about, but this mainly has to do with HUD housing, which has special considerations when we are talking about distributions to a loved one with disabilities from a trust. That has special considerations we have to be concerned about. It's not that HUD housing is undesirable. There's actually very nice HUD housing in some areas, but it's when we have a loved one who is in HUD housing, it does create a situation where the reporting, even though the rules have changed, the reporting can be challenging, where HUD could deem a distribution from a special needs trust to cause income attributable to the beneficiary and increased rent or disqualification from the program. So we have to be somewhat concerned about this. Now, I'm giving you a lot of information, so I'm going to go one step further on this slide, and I'm going to suggest a book. And this book is by a gentleman named Kevin Urbash, Urbatsch. And Jeff, maybe at the end of the webinar, can send out the information, but Kevin Urbash, Urbatsch, the former president of the National Academy of Special Needs Planners. He wrote a book, and don't worry about the title. It's called How to Administer the California Special Needs Trust. Don't worry about the word California, even though there is a California, Maryland, if you didn't know that. But this is a wonderful book. It's pretty thick, but the print is large. And Kevin does a great job of outlining public benefits and how to understand them. Maybe the more important issue here is that not only you understand them, but your trustee understand these public benefits. We want to make sure that our trustee does not inadvertently disqualify our loved one with disabilities from their programs because of mishandling of the trust assets. So just understand things like this are out here, these books such as How to Administer a California Special Needs Trust. We're not going to spend a lot of time on these slides because this is information you can take the time to look at yourself. I'm just going to pass through these because we're going to get to the main subject matter today, which is special needs trusts in the interest of time. So these definitions of disabilities. Note here on this slide that a home of any value is actually excluded. A vehicle is excluded. Furniture and belongings, burial plots, and so forth. Many of these things are excluded. However, this does not mean that your loved one with disabilities should actually own a home in their own name or own an automobile in their own name. However, their supplemental needs trust can own these things, and they do not have to own these in their own name. But again, the point of this slide is to show that even with SSI benefits, which is very restrictive and very means tested, your loved one with disabilities could own a home. So just know that this is something most people are not aware of. Jeff has graciously put in our 2024 benefit here, and SSI is now $943 a month. And of course, I have actually seen couples with resources of less than $3,000 with both getting SSI. Now, the concepts of unearned and earned income, these are things that are very important to understand as a parent, grandparent, or other family member of a loved one with disabilities. We want to know that when our loved one is earning income, and we know that it's good for them to earn income, we know that it's going to be congruent with a good life for them to be working and earning. But the problem is with our current system, which is very frustrating, it is possible to earn too much money. It is possible to be deemed to have too much money or too much income and be disqualified from SSI altogether. So we want to make sure we understand, and we won't go into all the details today, the concepts of unearned and earned income and how that reduces our SSI, which possibly could be reduced to zero, and thus disqualifying the person. So we want to make sure we don't have earned or unearned income to such an extent that it would possibly reduce our SSI to zero or below. One of the ways this can happen is through in-kind support and maintenance, for example. So if your loved one is living with you, you'll notice if they're getting SSI, that SSI attempted to reduce their benefit by 1/3, the maximum amount that they can reduce, so that now your child is only getting 2/3 of the amount that they could have gotten. Now, there are ways of dealing with this, and I'm happy to discuss that with you at another time. Many of you have dealt with this, so your loved one does not lose their 1/3. But imagine that they've lost 1/3 because you didn't rectify that in the ways that are possible to do that. And now the child is deemed to have income that's reducing and reducing their benefit, and now they get down to 0. So we want to be very careful about all this and make sure that we understand how it works. The SSDI eligibility, I'm not going to spend a lot of time on this, but these slides are for your review. Here we have something that we want to point out. We mentioned the disabled adult child benefit. We want to make sure we point that out here. Anyone who is disabled prior to age 22, and we talked about the 50% and the 75%. This can be very, very good news for many of you with a loved one with disabilities that you didn't know about this. And this can be a very happy thing because it generally means that their benefit in the future is going to be greater than it would have been just with SSI. Medicaid and Medicare, this information is really supplemental for you today. We're not going to spend a lot of time on it, but I wanted you to see these things. We know that one of the greatest issues is where will your loved one live? Will they live in a residence that is a group setting? Will they live in a residence that you left for them as part of your estate plan? Will they live in a residence that you purchased during your lifetime? So we know that a third-party supplemental needs trust, which we're getting ready to talk about, we know that that will allow for the ownership of a house within that trust with no payback. We're going to talk about that. But what this slide is illustrating is that if our loved one for any reason uses HUD housing or Section 8 housing, there are new rules, and some of them are favorable and some of them are not. And we're still evaluating those new rules from last year. And this is going to be something to be considered. I would say ideally, it's not a great situation to have our loved one live in HUD housing when they are the beneficiary of a special needs trust. But in many cases, it's unavoidable. So we just want to be aware of it. I wanted you to be aware of it. All right, so we're now going to get to the part that many of you have signed up for today to really understand. And this is the part about the special needs trusts. I personally think this is very straightforward information, and I want you to give yourself permission to understand it and don't try to overcomplicate it. But I think that many lawyers and many people in the public overcomplicate what I would say is a very straightforward strategy about how the government has provided a way for you to leave assets in further trust for your loved one, and that asset or those assets will be excluded from possibility of being spent down by the government. These are excluded resources for your loved one, and let's just get into that discussion now. And Jeff, if there's any questions, please interrupt me at any time. Let's talk about the types of special needs trust. This chart, I want you to focus right now on the top category called the third-party trust. And we're going to go from left to right. So we see here that this third-party trust, and now I'm going to give you, if you're writing this down or typing this information, I'm going to give you a mouthful. The third-party supplemental needs trust. The third-party supplemental needs trust. This is the bread and butter of estate planning. This is something that if you're on this webinar today, you should walk away from this today knowing there's no question that you can establish this kind of trust for your loved one who is disabled. And because you are a third party, whether you're a parent, grandparent, sibling, anyone who is establishing a trust for the benefit of this disabled person, and they are a third party, meaning they are a person who is other than the beneficiary, and you leave assets into that trust, whether it's IRAs, 401ks, life insurance, proceeds from an estate, a trust, whatever it may be, you pour assets into this trust, those assets are going to be exempt from the government scrutiny. Those assets are going to be for the benefit of the loved one with disabilities. And when they pass away, many years later, those assets will pass wherever you say they go, because those assets will not be subject to a lien or recovery by the state of Maryland. So that's our bread and butter. That is our third-party supplemental needs trust. So I want you to know that's what we're going to be focusing on today. But the middle category, the D4A category, and the bottom category, the D4C category, what in the world are these? Well, these are what we call first-party trusts. The best way to think about this is the third-party trust means someone other than the beneficiary is leaving money from point A to point B, straight from the third party to the trust for the beneficiary. Whereas the first-party trust example, the beneficiary has already received money. The beneficiary has money in their name, and that beneficiary is being disqualified from public benefits because of having too much money. This could be someone who receives an inheritance from someone. A well-meaning relative left a loved one with disabilities who's on public benefits, left them a large amount of money from an inheritance or a will or a trust or estate. Another example would be someone is injured at birth or injured in a car accident, God forbid, and they have now received a large amount of settlement funds that is going to disqualify them from public benefits. That money is in their sole name. So because of that, they are deemed to own that money until it is gotten out of their name and transferred out of their name through these means. And you can see here that the first party trust, the D4A type of trust, which is used for a lot of those types of situations, is for a person who is still younger than 65. But there is a payback to the state. So we're going to talk about that a little bit. This trust can be established by a parent, grandparent, guardian, court, or the actual person who is disabled if this person has the mental capacity to do so. So this is something that in a perfect world would be put in place just in case your loved one has money that comes into their name someday inadvertently. But it is not required to do good special needs planning from a fundamental level. So in a perfect world, you would establish a third-party supplemental needs trust and a first-party D4A trust, but most parents just establish the third-party trust to basically be part of, or loved ones, to basically be part of their own estate planning. But again, in a perfect world, everybody would also establish the first-party trust as well. The pooled trust, which is a good example, would be the ARC of Northern Virginia and other pooled type trusts are nonprofit organizations, and those pooled trusts can hold funds in a pooled manner, and most of them have a payback, just like a first-party D4A trust. And a good example of that, again, is it could be used by anyone at any age, but it is normally used in my practice. It's normally used for someone who's over 65, and many times it cannot utilize a D4A trust, or it's for someone who wants to keep the cost of administration of the special needs trust extremely low because there's a smaller amount of money involved. So that's a quick lay of the land of the types of special needs trusts that are available. Now remember, as we just discussed, the third-party trust is the best way of planning for the average person who is doing special needs planning for their loved one. And it's called a third-party trust exactly for that reason. It comes from a third party. The money's coming from third parties. For example, if you're a third party, you can establish a trust for your loved one, and other third parties, when they pass away, such as parents, if they were to pass away, they can also designate money to that trust. So some of you are going to have other family members in addition to yourself who might leave money for the loved one. Now, we don't want to do these things. You've either thought about this or seen it or unconsciously thought about it. We simply don't want to do these kinds of arrangements. So some people don't plan at all. Fortunately, this is very, very few people in my experience, but some people don't plan at all and they just leave an outright inheritance to their loved one with disabilities. Very foolish, very unfortunate thing to do. Fortunately, there would be a way to get that money out of the loved one's name, but we don't really want to do that. Or they leave assets in a trust that they think is a special needs trust, or they got bad advice and they leave assets and a non-qualifying trust, meaning a trust that is really not going to protect the beneficiary from losing their public benefits. So that is a problem, and we don't want that. Some people try to approach this and say, well, I'm just going to disinherit my loved one with disabilities and leave it to another person. The problem with that, as we look at the last set of bullet points here, is that if we leave assets to another person, that person, their creditors, their potential divorcing spouses, their potential death, where they leave the money inadvertently to someone else through no fault of their own. They didn't expect to die and they left the money to someone else. Or it could be just lost to Uncle Sam. Maybe Uncle Sam had a tax lien against this person. So this is just not a very safe way of doing things, and it puts the assets beyond your control, and it also puts the assets potentially beyond the control of the person you're leaving it to use for the benefit of your loved one with disabilities. So we don't want to make these mistakes. We want to recognize this and really say, hey, we're not going to fall into that trap. So again, just to reiterate intentionally, the third-party trust is where the person who is the person with disabilities did not create the trust. It does not hold their own money, and the beneficiary is not the trustee, and so forth. Now, the first-party trust, which we're going to talk about in just a second, sometimes is absolutely necessary. A good example would be that person receives an inheritance they didn't expect. That person is injured and didn't expect to be injured and has this large settlement amount. That person is the child of a military veteran, and the military veteran now under the Military Pension Act, Pension Protection Act, I should say, can leave their military pension in a first-party trust for the benefit of their loved one, and that can be assigned directly to the trust. So there are times when we can't use a third-party trust, but we definitely want to generally use the third-party supplemental needs trust because there are no payback requirements, and it actually can be revocable and flexible during your lifetime, even though there are some situations where we would make a third-party trust an irrevocable trust. Jeff, I'm going to take another sip of water. Please interrupt me if there is any questions.
Thanks, Steve. Let's pause for a couple questions. Thank you. First one is, we don't discuss ABLE accounts in this presentation too much. We have Maryland ABLE coming in to visit with us on March 6th. Would you like to talk just a bit about ABLE accounts and what they are and how they fit into planning and special needs trust for just a minute?
Yes, I'm happy to do that. So thank you for that. ABLE is Achieving a Better Life Experience under the US code, the IRS code 529 plan, 529 provision. And basically, we have a situation where the government has chosen to honor, thank goodness, honor people with disabilities by saying they can now have a tax advantaged account where they can save up to $100,000 without losing benefits if a person is on SSI. So the SSI recipient can have up to $100,000, contributed at the rate of $18,000 per year per person, which is the exclusion from the annual what is called the annual exclusion from gift tax amount. Last year, that amount was $17,000 per person. Now it's $18,000 in 2024. And if a person is not on SSI, they can have more than $500,000 in this account, which continues to grow in a tax advantaged way. Now, you get the tax advantages as long as the account is used for qualified expenses. But for some people, even if the account is not used for just qualified expenses and they were to lose the tax advantages of the account, it's not necessarily the worst thing in the world. But that is what the premise of this is. Now, the real premise is to give persons with disabilities more independence, more self-determination. So it's a wonderful thing. I would say ABLE is going to be mainly for the person who is higher functioning and can really appreciate the fact that they are getting a tax advantaged, more independence-oriented account where they're finally being recognized. And by the way, the current rule, which is the person has to be disabled prior to age 26, that has now been changed coming up in 2025. As long as a person was disabled prior to 46, they will be able to have an ABLE account. So ABLE is not a special needs trust. It is not supposed to be an alternative or a substitute for a special needs trust. But in my opinion, it is an adjunct to the special needs trust planning. And a good third-party special needs trust, in my opinion, is going to give the trustee the ability to fund an ABLE account to whatever extent that it can be funded if the trustee chooses to do that. But the idea is to give the person more independence. In recent years, I have seen families with loved ones that are not as that high functioning, that cannot necessarily appreciate the benefits of an ABLE account, but I've seen parents nonetheless create ABLE accounts across the board. So we want to be aware that the ABLE account is exactly that, achieving a better life experience to enhance the quality of life for a loved one with disabilities. But it is not a substitute for a special needs trust, even though it sounds like it might be. And lastly, the ABLE account in Maryland is not a payback account. Federally, ABLE was established as a payback account, meaning whatever amount is in there at the time of the beneficiary's death would be paid back to the state. That still exists as a federal rule, but Maryland abolished that rule. And right now we have a situation in Maryland that the Maryland ABLE is not subject to a payback. So I hope that helps, Jeff, and I know that was a little bit long-winded. I'll wait for the next question.
Thank you so much, Steve. Very helpful. Next question is, for an adult or child to move from SSI to SSDI eligibility, say on the initiation of our retirement, does the adult child have to already have been eligible for SSI, i.e. at the time of the potential move from SSI to SSDI?
Well, I apologize. I got lost there that almost at the end there. It said, do they have to be on SSI at the time? Can you read that again, Jeff?
Yes. Does the adult child have to already have been eligible for SSI?
Well, I think the answer to that is maybe twofold. One is, generally speaking, the child would have been on SSI because by definition, they would have been disabled prior to 22 and would have petitioned for or applied for SSI and been on SSI. There are times when an adult child was not on SSI prior to 22 or did not apply for Social Security, in my experience, did not apply before 22. And for a good example of this would be cases where I've seen someone who's 26 or 27 years old be approved as a disabled adult child, even though at the time, at age 26 or 27, they were on Social Security disability on their own work record. I have seen cases where the records indicated that this person was a disabled adult child prior to 22, and those records were still available, and that person was awarded. So I guess the answer in my experience would be, subject to further research, would be that yes, it is possible for a person to get disabled adult child status and get SSDI when they are beyond 22 and had never been on SSI. At least in my experience, that was the case. And then, of course, most people are on SSI prior to 22 if they are disabled, but not everybody. There are people in that middle ground that have not actually applied for SSI.
Okay. One or two more, if it's okay. How
Sure.
are any profits from investments in the trust taxed?
Thank you for that wonderful question. This is a long-winded discussion that I won't be able to go into now, but the idea here is for you to remember this. When you are creating a supplemental needs trust during your lifetime, and you make that a revocable trust, let's say, you want that flexibility that it doesn't become irrevocable until your death, then the advantage of that is there are no special tax rules. You would just simply continue to pay the tax on the money or on the income that's created by the trust if you funded that trust during your life. And that is called a grantor trust. So you just continue to pay the tax on the income that you might have funded into that trust during life. Let's say, though, at your death, this trust is irrevocable. Then what happens is that special needs trust, the supplemental needs trust that's irrevocable, it's going to have its own tax ID number, and it's going to pay tax at the trust tax rates. And when you look at that, you're going to initially say, oh my gosh, that is a huge amount of tax. Trusts are taxed very aggressively. But the truth is that there are going to be distributions out of that special needs trust during the life of the beneficiary each year. And those distributions are going to carry out income to the beneficiary. So what's going to happen in the end, which is a very short version of a long discussion, is that the child is going to be attributed the income from the trust. So the trust does not have to pay 37% tax on that income. But now you might be worried, well, gosh, if my child is attributed the income, it's going to ruin their benefits. But that's not going to be the case. The income will largely, if not all, be attributed to the child, but it will not disqualify the child, because income that's attributed to the child for IRS purposes is going to be taxable income. And if there's taxable income or tax, the trust will pay for it. But the income attributed to the child for Medicaid purposes cannot disqualify the child from their benefits. So the long, short answer on this is that the trusts are going to be taxed irrevocably at a very high rate, but that's going to be mitigated, it's going to be nullified by the handling of the distributable net income to the beneficiary, so that the trust does not pay that high tax rate, but the tax rate will be the tax rate of the beneficiary, which is usually very low. So that's a broader discussion and the quickest way that I can answer that question. Thank you.
Thank you, Steve. And one more, does it matter in what state the trust is set up?
Thank you for that. Great question. The answer is yes, it would matter. So let's say you established a trust in this particular state. Well, that trust is going to be governed under that state law. And if your loved one with disabilities lives in that state, that trust, in my opinion, should recite the Discretionary Trust Act or whatever comparable trust act is the case in that state that protects people with disabilities. But what is a good thing to know is that when you create a modern supplemental needs trust, you can provide for the flexibility that if the child lives in that state, the trust is established under that state law, or if the child moves to another state, the location of the trust, which is the situs, and the taxation of the trust, meaning the state law and the taxation, would move to a new state. So a trust in today's world can be drafted where it's situated in one state, but it actually could be moved to another state if it's necessary. So to me, it does matter. There are circumstances where someone established a trust in a certain state, their child no longer lives there, or they established a trust in Maryland, but the child lives in another state and nothing happens, the trust never gets updated. And I'm not saying anything bad would happen, but in a perfect world, if a trust moves to another state, the location, the situs, and the state law should change, and the trust should be amended, in my opinion. All right, Jeff, if there's no more questions, I'm going to move on.
Yeah, let's move on for right now. Thank you very much.
All right, thank you, Jeff. And in the interest of time now, we're going to talk about choosing a trustee. Trustee selection is maybe possibly, other than advocacy for your loved one, the biggest consideration in special needs planning. So some of you are going to have family members that are going to be obvious choices. Some of you are not going to have those obvious choices, and you're looking to hire a professional like an independent brokerage firm or bank or trust company. Some of you are not going to want a corporate trustee that's independent. You might be looking for an attorney. For example, our firm administers trusts under our Waypoint Fiduciary Services mantra, and we do a lot of trust administration. So you're going to be looking at these particular types of trustees, and you're going to be making intelligent choices. And this is going to be a question of your family relations, your personal situation, how much assets under management are going to be in the trust, the fees and what those might be as far as the costs of ongoing administration, conflicts of interest and whether or not family members are the right choices, knowledge and willingness and experience, or just making sure that if you are going to choose a family member, that your family member knows where the resources are and they know that they can hire professionals to make sure that they are crossing all the T's and dotting all the I's. So we're giving really kind of short service to this particular topic today, but we have a whole webinar on trustee selection, and I encourage you to look at that webinar or to look at the next one we put on. And this is truly a huge issue, and to my mind, if no matter who you select as a trustee or your successor trustees, you're going to want to build in flexibility for future changing situations, whether a trustee needs to be removed, whether a trustee is doing a good job, a trustee becomes ill, whatever the situation may arise in the future, to me, we want to build in the flexibility necessary. Look at this last bullet point. I can't go on without looking at it. The ability of the trustee, let's say this is a person who has great ability, but are they willing? Or is this person a great candidate, but are they really committed and are they willing to pass the test of time that they're going to stay with the program and really advocate? And we're going to talk about that in just a second here. A trust advisory committee. This is something that is going to be more applicable to some of you and your situations than others. I would recommend that you include a provision in your trust that simply says this: if my trustee needs resources, well, he or she knows that they can get those resources. They can hire professionals, advocates. They can get advice from attorneys. They can do these things. Well, we need to make sure that they know that. But if they have an issue that involves a broader problem, a problem that they really need advice from the coordinator or the psychiatrist or their family doctor, they need to convene a committee of people. This is a nice thing to put in there, even though it may never be used. I personally have had to use this kind of thing in my own practice when I'm serving as a trustee. But here, we want to make sure that people are aware that they have this ability. And for some of you, you will not include such a provision, but generally speaking, this is a good idea, especially for loved ones that have health issues that have to do with mental health and other issues that are sometimes traumatic in dealing with. Trust protector, we talked about this special fiduciary as a nice way of providing flexibility in the trust. Their general authority has to do with removing and replacing trustees, being able to review an accounting because the loved one may not have the ability, or usually does not have the ability, to review their own accounting, or to make changes. This may be one of the biggest issues, to be able to amend the trust administratively if it needs to be changed over time because of changes in the laws, such as the recent changes with the Secure Act and so forth. So we want to build in flexibility, and we want to give the trustee room to be able to maneuver if there are big issues that have to be addressed, that need to be addressed by a committee. Now, this is just one view of a supplemental needs trust today. Here, this is kind of a visual. We have the trustee, huge issue, who the trustees are going to be. The trust protector, we talked about this. This could be an independent person. It could also be a family member in special needs planning, although ideally, this would be in the bigger scheme of trusts and the bigger outside world of trust, this would be an independent person, but it can be a family member in special needs planning. The Maryland ABLE provisions or ABLE provisions in the trust, the advocacy provision, the memorandum of intent, we've talked about this. Trust advisory committee, we just talked about this. I'm going to stop short of the special retirement plan considerations for just a second. Why am I reemphasizing these bullet points? Well, we know about them today, you know about them today, but does your trustee really know about them? We want the trustee to be educated. We want the trustee to read the trust. How many of you would be surprised to know that the trustee many times may not even fully read the trust? So we want to make sure our trustee is available, that they are reading the trust, that they understand public benefits. We're going to talk about that here in just a minute. Let's go back to special retirement plan considerations. Some of you are saving most of your money in retirement plans. And when you pass away and you leave those retirement plans to the supplemental needs trust for the benefit of your loved one, you're going to want to know that your retirement plan benefits are maximized. What do I mean by that? If you have a non-Roth IRA, which many of you do, meaning a traditional IRA or 401k plan, a pre-tax plan, when those assets come into a special needs trust, your loved one with disabilities, if they are truly disabled and are under SSI or SSDI, in most cases, they are going to be considered a designated beneficiary, but one step beyond that. They are going to be considered an eligible designated beneficiary, which means under the Secure Act, they are exempt And that means they get preferable tax treatment if your loved one is chronically ill or disabled under the law since 2020. And now those rules have been updated in the Secure Act 2.0. They are now going to be eligible to stretch out their retirement plan. Your healthy child or healthy beneficiary is not going to generally be able to stretch them out. That's why many of you have heard of the 10-year rule, where they have to take all the distributions in 10 years. But your loved one who's chronically ill or disabled will be able to have the maximum tax advantage of stretching out their retirement plan assets the way they used to be able to do that before the Secure Act in 2020. So we want to be aware of this. We want to be aware that our loved one is an eligible designated beneficiary, but we also want to make sure that their supplemental needs trust is an eligible designated beneficiary so that they get to take advantage of this tremendous benefit. And Jeff has been so kind to insert a Secure Act chart for us here, or a slide. And we just want to be reminded that this came out in 2020. It's been updated now into the Secure Act 2.0. And it provides that the following individuals are exempt from the Secure Act: surviving spouses, minor children, a disabled person, as we just talked about, a chronically ill person, or a beneficiary who is not more than 10 years younger than the account holder. What does all this mean? Well, if we look at this next slide, which is or next bullet point, excuse me, which is quite confusing, the IRS calls your third-party supplemental needs trust an applicable multi-beneficiary trust, an AMBIT. So who could make this stuff up? But this is what the IRS said. And the good news here is, again, that AMBIT is excluded for the Secure Act. Your loved one is excluded as an eligible designated beneficiary. And for some of you, the idea that you might want to include a charity, and you'll see this here in that next to last bullet point. Some of you are very committed to charity. Maybe a charitable organization, nonprofit organization, made a big difference in your child's or loved one's life. And now you want to leave a legacy to that charity. Well, prior to a year and a half ago, you could not do that without causing the disruption of your disabled child's eligibility, or the nullification of their eligibility. But the good news is now we can have our cake and eat it too. We can plan for our loved one with disabilities, have their retirement plan treatment be very preferable, and also be able to leave a legacy to charity without that disqualifying the child. So all plans should be reviewed, whether you have an existing plan or a very, very old plan that's not more contemporary. All plans should be reviewed, including regular estate plans about this whole issue of the Secure Act. As we think about trustees, as we start to head toward the finish line of our presentation, we mentioned trustee duties here because this is huge, obviously. And in the world of special needs, here are these wonderful trustees that Jeff has found photos of. These people understand all of these concentric circle items. They are accountable. They keep records. They keep the beneficiary informed. They comply with their duties. They are just really on top of things. And we know in a busy day-to-day world, this is very difficult to find somebody who is like this. They understand basics of financial investing. Now, they don't do the investing themselves. They understand that they have to hire professionals. They understand that it's their fiduciary duty to hire a tax professional, to hire legal professionals, to hire financial advisors, and to make sure that they have an investment policy statement that says, I've done my due diligence. They have invested the assets and according to fiduciary standards for the best interest of this trust and the beneficiary. So they understand that important thing. But maybe one of the most important things they understand is advocacy. What is the best interest of the beneficiary? Making sure that public benefits are preserved, promoting the quality of life and independence. Would it surprise you to know that the average trustee does not understand the public benefits of the person with disabilities? They might understand the surface of it, but really not understand the full public benefits to which this person is entitled. So this is what we want to shoot for, and to have a very high threshold of standards for our trustee. A trust can pay for things that are for the benefit of the beneficiary. A first-party trust is a trust that is more stringent, but it's still a sole benefit trust. A third-party trust is going to be more liberal in what things can be used for the benefit of the beneficiary. And we're happy to send you a list of things that a trust can pay for, although that list is not exclusive. So just know that this is another piece of the trustee's education. We talked about how much should be funded. This is going to be a case-by-case situation with your financial situation and whether life insurance should be a big tool. In a perfect world, all special needs families or someone who's planning for a loved one with disabilities would buy life insurance for no other reason than making sure that that funding mechanism is permanent, because we don't know how much we're going to have at our deaths. So that's not going to be true for everybody, but we want to look at this, use the resources of a financial advisory service, use your planning team and the collective knowledge of that team to try to make headway and to try to make sense of how much to actually fund into the trust. We talked about the first party trust, and I'm not going to go through that again. This is the alternative trust where someone has received assets that they shouldn't have in their own name. Thank goodness, under law that stems back to 1993, the federal government and the state government provide a way of divesting the person of their assets, but still using those assets in a first party special needs trust for their benefit. But this is a payback trust. This trust must be paid back to the state of Maryland or any other state where the person might have received benefits if they pass away. So we have to judiciously use this trust. In some cases, it is mandatory, such as the military pension situation we talked about, or accident or settlement situations or birth injury situations. So this is just reiterating that. And even if a person is not a person that has assets in their own name, or is just a person that has a supplemental needs trust that's a third party type for their benefit, sometimes it's a good idea to implement a special need trust of the first party kind, just in case, to always have that trust available if it is ever needed. Sometimes that's a good idea. And it's not expensive to be able to do that. So let's just talk about now in closing, how do we establish a supplemental needs trust? Well, the first thing to do is just to really understand that it's just a process. And when we engage in a process of learning, engage in a step-by-step process, that's what our firm is all about, is really to help you start the process and get to the end. And we get started with review. Here is a bit of a narrative about that for you to review later. But we really just want to go through a series of steps of review, honing the document so that you understand it, your fiduciaries understand it, and you'll notice that we might even have a family meeting with your fiduciaries to make sure that everything is not only implemented and funded properly so that it will actually work, and there's flexibility in that plan, but that your fiduciary really understands it. We talked briefly about addressing the issue of whether to have guardianship of your adult child or whether to avoid guardianship through the use of supported decision-making and a combination of supported decision-making and financial powers of attorney and so forth. This is going to be an advanced medical directive, by the way, and this is going to be a case-by-case basis based on your loved one's capacity or lack thereof, the family's goals, and it's all a bunch of factors around the self-determination, excuse me, of your loved one. There are two types of guardianship for those of you who have to pursue guardianship. Guardianship of the person, which is the most common type, and guardianship of the property or estate. This is where a child has assets in their own name or assets, for example, in a recent case we are dealing with where a loved one with disabilities is inheriting assets and someone has to be appointed as a guardian of the property to be able to represent them in the probate court. We talked briefly about supported decision-making. Here is a couple of slides about supported decision-making. I would encourage you to find out more about it or to watch our webinar on it or to read my article about it of a couple of years ago. I'm proud to say that I was able to get a lot of information out there in this article, and it was #1 on Google, at least for a while, I think, Jeff. And its big advantage of reading this article is that it actually goes through a little bit of the legislation and helps you understand that this was a landmark thing in Maryland where Maryland is finally getting up to par and beyond all of a sudden by recognizing supported decision making and also understanding whether it's a good thing in your mind or whether it's something that is somewhat confusing, which it is for some parents and loved ones, but how it helps the person with disabilities conceptually have more self-determination. So the way I would think about it as we wrap up is supported decision making is a tool, and the person is empowered to make their own decisions to whatever extent possible. And it gets away from the traditional notions of what disability is, what incapacity is, and it can be written, it can be verbal. It's so broad that it's very confusing. So again, I recommend that you watch the webinar on supported decision making, or that you circle back with me or other attorneys here at our firm to discuss this issue. So as we wrap up, I just want to thank you again for attending. I want you to think in terms of creating a memorandum of intent, looking at your own estate plan and making sure that's solid, not only for you, but as it trickles down to your loved one with disabilities, how important that is to take care of yourself first, and then how that relates to taking care of them. Establishing the supplemental or special needs trust as part of that plan, talking to your advisors and having a team of advocates that work for you in a collaborative manner, and really understanding how retirement plans work with special needs trusts today, really just allowing yourself to take advantage of the education that's available to you. Understanding public benefits, really just engaging in a conversation of an expanding view of what you want in the privacy of our conference room, and making special needs planning a part of your plan and understanding why. That was a lot of information, and again, I thank you. We suggest that you set an appointment with us. We want to help you not only be educated, we're very serious about it. We have been very, very blessed to be part of the special needs planning community for many years here in Maryland. And I thank all of you for your support of our efforts to educate and for being here today. When you engage in a discussion about these types of issues, you are creating an attorney-client relationship. So there is an attorney-client privilege. There is a privacy element where even if you do not become a client. So in this respect, there's nothing to fear. We want to see what your situation is like. If you don't mind creating or completing an estate planning questionnaire, you're kind of engaging in a process with us where you're having to do some work to provide us information, and we have this confidentiality, and there's absolutely nothing to fear. We want to look at your current estate plan if you have one. If you don't have one, please don't be concerned. It is not difficult to put your own estate plan together. We are known for helping our clients, hand-holding our clients, compassionate approach with our clients, and we're going to take care of you if you step forward and want to have a consultation with us. We want to help you have an advisory team or a collaborative team. If you do not have one, or you only have a partial team, we want to help you get that in place, and we will help you along those lines. If you have questions, which many of the questions today were excellent, we want you to bring those questions, and we relish the opportunity to, to answer those questions for you. We do not charge generally to review existing documents, so don't be afraid to say, hey, Steve, we want you to review or have other attorneys here review your current documents. Mainly, as I mentioned from the outset, we want to give you time to think. We want to give you space. We have contemporary high-tech conference rooms with 77-inch whiteboards where we illustrate things for people so that you can have a great understanding of the process and of the documents and the technical issues. We also do Zoom meetings and other Microsoft Teams meetings for those of you who cannot get into the office, although we recommend that you get into the office. So with that, I want to thank you again. I hope you stay warm. I hope you have a wonderful year ahead, and don't be afraid to ask us to help. We are here to help and be a resource to you. Jeff, I'm going to turn it back to you.
Well, thanks, Steve. Very helpful information, lots of great information. I never get tired of listening to that presentation. Always learn something, and I hope you did too. To our attendees, I'm sure you did. Lots of great questions, and we have a few more. And so now would be your time to get those final questions into Steve. and we'll go ahead and run through those. I think we're going to be right on time today, as we always end up being somehow. It's funny how that works out. So we'll go in with first one. And Steve, first one is, can a trust be run by two trustees?
Thank you for that. Yes, the answer is yes. You could appoint co-trustees. And one of the things you're going to be thinking about is, are you going to go with the traditional approach where you have two trustees that are acting jointly only? They must make all decisions together jointly, which is quite common. Or do you have a situation where you want to empower the trustees to act jointly or individually? There are times when that might be the case, but generally speaking, you would have joint trustees, two trustees that have to act jointly. That is very common.
Next, can an education trust be transferred into a special needs trust?
Thank you for that wonderful question. The answer is it's going to depend. I would say off the top of my head, not having seen the situation, that the answer would probably generally be no, but there is something called decanting. And decanting is something that Maryland now has that it did not have for a long time. And now as of October 1st, we have a decanting statute, which allows the translation or the evolution, I guess, of one trust into another form of trust. So it's possible that this trust could be decanted. I am not sure it could be. This would be a case-by-case situation. And of course, it also depends on whether an education trust that you're referring to is funded. So we'd have to know, take a look at the trust and actually see if this trust is funded. So I'd say generally no, but I'm not going to rule it out as a possibility.
Okay, and stay tuned, as that word decanting is going to come up in your invitations in the next 6 or 7 weeks. Next question, when using a life insurance policy to fund a special needs trust, can the policy be provided by your employer, or does it need to be a policy that you get independent of your employer?
Thank you for that question. That's a very important question. The answer is your employer provided life insurance can fund a third-party supplemental needs trust. There's no question about that. You're just going to beneficiary designate that to the trust. The issue becomes, it doesn't have to be an individually owned policy, but as you think in terms of life insurance as a tool, if you're going to provide it as a major tool, which is situation by situation, you're going to need to own that policy individually if you're going to want to make that policy permanent. Meaning if you're going to get life insurance as a funding tool to be there no matter how old you are, so that, for example, when you leave your employer, if you were to lose that employer provided life insurance, now you don't have it as a funding tool. So it's really going to be a question of, yes, you can use it, you can beneficiary designate it while you're employed and while you still have that, but the question is the broader use of life insurance and whether or not it should be permanent, because we don't want it ever to end prior to our death and not be effective.
Okay, so it looks like those are all of our questions for now. The last question was regarding the link to the article, which leads me to my final thoughts here. Again, thanks for being here. This is the presentation where I always send out probably the most substantive follow-up message. As you know, most of you, I send out a follow-up email, which includes our video from today, the slides again. I'll send out the most recent Maryland ABLE webinar that we offered, trustee selection, supported decision-making. I'll send out Kevin Urbash's book link, the article by Steve on supported decision-making, and much more. So you'll get a lot of information. Be sure you read through it, check my grammar, and I hope it's very helpful to you. Lastly, as it relates to our upcoming presentations, January 23rd, 7 p.m., if you're looking for an evening presentation, we'll have estate planning and elder law essentials, and that's in partnership with Timic Financial. We'll be presenting on the first evening, and then Mark Timic of Timic Financials talks about Social Security planning and retirement planning the next 2 nights. That's our semi-annual retirement series with Mark Timic. On Friday, the 26th of January, the critical need to update your estate planning with Steve Elville at 10 o'clock. And then on Wednesday, January 31st, understanding estate and trust administration at 10 o'clock in the morning. So those are our next few. And then on March 6th, just jumping ahead just a little bit, We'll have Kelly Nelson with Maryland Able coming to visit us, and we'll have a full slate of events posting soon in February as well. So we'll check to see if we have any final questions here. Doesn't look like we do. And we'll call that a wrap. Steve, thank you for being part of our Elville webinar series today. And we look forward to seeing you again soon. Any questions or needs, feel free to reach out to us as always. We'll look forward to being a resource to you. Have a great day. Stay safe and be warm.